Welcome to Immigration Explained Simply.
Hey everyone, welcome back to an all-new episode of Immigration Explained Simply with attorney Aisha Nanyanzi. I am your host, Mike Leon. You know, Aisha here is the founder of AKN Immigration, based out in Gilbert, Arizona, and she's been serving clients nationwide and abroad. And in today's episode, we're going to be talking about removal proceedings. Aisha is going to cover what they are, how they begin, who they apply to, and what options still may be available, especially once the case is in immigration court. Aisha, it's so good to see you. You can kind of hear it in my tone because this is a huge focal point right now, not only in news, but everywhere. Everyone wants to understand what is happening around removal proceedings. So, apropos to have you on, can you explain at a high level what removal proceedings are, how they differ from other parts of the immigration process that maybe people are a little bit more familiar with?
Thanks for having me, Mike. So, basically, removal proceedings it is exactly what it sounds like. The US government is trying to remove you from the United States for one reason or the other. And I think the easiest words in layman's term is they're trying to deport you back to your home country. You are not born in the US. You are not you are not a citizen of the United States, and they are basically trying to deport you or to remove you from the United States.
So, my understanding is, and this is why you're the lawyer to explain it, that not everyone can actually be placed into removal proceedings. Is that true first? And then who generally cannot be put into the removal proceedings? And what are some factors that tend to matter in that determination?
So basically, the the easiest answer to who cannot or who should not, I will say who should not because we have seen it happen mistakenly. Who should not be put in removal proceedings are US citizens. So people who are citizens of the United States are not supposed to be put into removal proceedings. Whether naturalized or born is a whole different situation. People who have lawful status, green card holders, asylees, refugees, people who have TPS, people who are here on lawful non immigrant status, H-1Bs, student visas, and all that. Now, the caveat to that is all the people that I mentioned, other than US citizens, can be put into removal proceedings for one reason or the other. Say if their status expires. So you're here on a B2 visa, you've been given authorized stay, and then your authorized stay expires, you do not return to your home country. Removal proceedings can be initiated against you, especially if you don't have a pending application. People who have already overstayed their visas and people who have committed certain crimes can also be put into removal proceedings if those crimes make them removable.
Aisha, I want you to expand on that because I think it's very important. So, what other situations most often lead to a case being referred to immigration court? You mentioned a few about crimes, but I think there's a differentiator between misdemeanors and felonies. Like, explain all of that of what other situations most often, maybe missed court appearances, things like that.
Yeah, so I mean, the other situations again, like that could lead you to be in removal proceedings, and this will be before the immigration court. As an example, you apply for asylum, okay? So affirmatively with the asylum office. Either one, you do not show up to your asylum interview, or you are interviewed, you're out of status, and the asylum officer fails to make a decision or to make a determination, they can refer you to the immigration judge for removal proceedings. Again, the other situation is say you apply for a green card. On our last show, we talked about marriage based green cards. So let us look at a situation where either the I-130 petition was denied and then the green card application was also denied, or just the green card application was denied. Then they can issue what's called a notice to appear and send you to immigration court to start removing you if you commit an aggravated felony. Now, just so we're clear, an aggravated felony for immigration purposes is different in criminal law. So you could have a misdemeanor in criminal law, but it could be an aggravated felony in immigration court. and there has to be a conviction. Again, a conviction, the definition of a conviction in criminal law is different from the definition of a conviction in immigration court. So those are some of the situations where you could end up in removal proceedings.
It's a lot for people to understand. They don't understand the differences between the courts, even the judges as well as how they come to become judges. So I did want to ask you though. You mentioned the NTA, so let's talk a little bit more about the notice to appear. What is it? Why is it such an important document in an immigration case?
So the notice to appear is the document that initiates removal proceedings. So what this document does, it lays out a set of allegations. It will say, you are not a citizen of the United States. You are a citizen of Ghana. As an example, you entered the United States on date ABCD on this status or no status. You are authorized to stay for this period of time and you exceeded that period of time. You are removable under a specific section of the INA. It could say you are granted lawful permanent residence on such and such a date. You are convicted of a crime, ABCD, and that is an aggravated felony, or that is a crime that you have convicted within 5 years of being admitted as a lawful permanent resident. So the notice to appear lays out all those allegations, and then it also lays out the section under which the Department of Homeland Security is charging you to have you removed. And you need to respond to that, whether you concede or deny what they are saying. And then you need to basically list the application for relief. And the application for relief is what are you applying for in order not to be removed from the United States.
Yeah. So, and you just kind of wandered into it. So I want to expand a little bit. So now the case is actually in immigration court. You mentioned about the relief here. So what other kinds of relief may be available before an immigration judge, depending upon obviously the person's situation?
So some of the forms of relief that we can request for termination of proceedings. We did that for one of our clients who had been put in removal proceedings, but after digging a little bit, we found out that our client had actually become a U.S. citizen, derived U.S. citizenship from their mother in 1988. So in that situation where you can show that this person derived U.S. citizenship, you can ask the judge to terminate proceedings because this person is not removable. Now, if this person is removable, you can apply for, as an example, asylum, withholding of removal, or relief under the Convention Against Torture if this person is afraid to return to their home country. You can apply for non-LPR, which is non-lawful permanent resident, cancellation of removal in that situation. You can also apply for LPR cancellation of removal. This is someone who had a green card. They're trying to take it away for one reason or the other. If they're eligible, you can apply for LPR cancellation of removal. We can also apply for VAWA cancellation of removal. Again, this is someone that was abused by a U.S. citizen, a lawful permanent resident qualifying relative, and now they are applying for cancellation of removal before the court. We can also apply for a green card. Someone may be married to a U.S. citizen or they have a qualifying relative who has already petitioned for them, and we apply for a green card. We can apply for waivers. We see this in situations where someone was issued a green card erroneously and USCIS did not catch up to it, maybe until the naturalization stage. So basically they apply for naturalization and USCIS realizes, oh, we shouldn't have given you this green card for reasons A, B, C, D, but this person already has the green card. So they initiate removal proceedings to take away the green card because only the judge can take away that lawful permanent resident status. And if the person qualifies for a waiver at that stage, we can ask the judge to give them a waiver so that they can keep their green card and go ahead and naturalize.
Yeah. So many moving pieces, and it funnels into this follow-up beautifully, which is first, two-parter. How does the timing around the removal proceedings affect the options? But also, we talked about this in a previous episode, that getting the early legal guidance, why does that matter so much, especially when you get served with this notice to appear?
So the timing is really, really important. And this also plays into, again, whether or not what kind of relief are you going to apply for before the judge, before immigration court. There are applications for relief that have some sort of deadlines or have some sort of bars surrounding the deadlines. As an example, if you're going to apply for asylum, you must apply for asylum within 1 year of entry into the United States. Now, there are a few exceptions to that, but that is the general deadline. So, assuming you get this NTA and you do not timely apply for asylum and you do not fall under any of the exceptions, you can see how that bars you, that makes you ineligible for asylum. Um, we have, as an example, cancellation of removal, where you have to show 10 years physical presence or 10-year presence. And sometimes the issuance of that NTA can stop that clock. We call it, the stop time rule. It can stop those 10 years, even if you have been physically in the United States for the 10 years. Now, an attorney looking at your NTA and seeing whether it's defective and seeing whether there are any issues with the NTA can help you. So basically, involving or getting legal guidance from an attorney immediately after you get the NTA will help you with a lot of these issues, because some of these things, failing to do them in the beginning,
Right.
will buy you. You cannot go at the end of the day and say, oh, I did not know this, right? So they charge you under the wrong section of the INA. You go to your first hearing and you concede to it. You say they are right. You cannot then turn around and say, oh, they were wrong, because you already conceded to that. So looking at that NTA, analyzing it, and holding the government to their burden to prove all the allegations in those NTAs is very, very important.
Aisha, as we kind of land the plane on this episode, I would love for you to talk to that person out there that maybe is facing removal proceedings. What's something very important that you would want them to understand about the process itself? What can help it with respect to reducing the confusion or maybe even the fear that they may have as this moves forward?
The thing I can tell someone who just received their notice to appear is one thing I really tell people: consult an attorney, consult someone who has the experience. It doesn't have to be me, it doesn't have to be a paid attorney. There are non-profits who will help you with this. Make sure you understand what exactly you're being charged with. Make sure you understand your options. Now, I say this to all my clients a lot during my consultations. The people that we work with are very smart people, and some of these people are highly educated. Some of these people have a lot of accomplishments, and they can absolutely do it. Maybe they can Google it, they can chat GPT it, they can understand it. But immigration law is very technical, especially when there are crimes involved. It's not as simple as saying, I did not do this, I did not do that, or I did not go to prison. You can have a conviction for immigration purposes even if you never set a foot in prison. The definition of a conviction is completely different. So even if you want to do this on your own, at least spend an hour, find resources out there, find a nonprofit, and have them explain to you what the NTA is, and then make the decision whether or not you want to do this on your own, which is very understandable as well.
Yeah. Talk to an attorney. I know one. Aisha, thank you so much for the time and the insights. I appreciate it.
Thank you. Thanks for having me, Mike.
That wraps up today's episode of Immigration Explained Simply. If you or a loved one has questions about removal proceedings or other immigration matters, can you do me a favor right now? Visit aknimmigration.com. You want to learn more, you want to schedule a consultation with Aisha and the team, and do me one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with somebody who could be going through a removal proceeding themselves right now. As always, I am Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.